All right, everyone. I think we're going to get started on our rent escrow overview for volunteer attorneys and staff. Thank you, everyone, for coming. We will be recording this so you can watch it in a time that makes the most sense to you. So let's go ahead and get started. So we at LSV, we offer a lot of eviction defense work in the form of rent escrow clinics that we operate in 4 counties in Vermont. And that is staffed by folks at my office. So I'll introduce myself. Again, my name is Maggie Fry. I'm the managing attorney at Legal Services Vermont. And my colleague will be presenting this training with me today, and I will let him introduce himself.
So I am my name is Bradley with Legal Services Vermont. I'm the managing the pro bono manager and staff attorney, and I am fussing with my camera really quick just to make sure that everything is working, and then I'm going to go back to the presentation here in just a second.
Sure.
All right, and so you folks should see the presentation now, full screen, is that right?
I do not see it.
You do not see it. Okay, so I'm going to do
There it is.
okay, sounds great. All right. And Maggie, I'll let you take it from here.
Great, thanks so much. So as I was saying earlier, we operate rent escrow clinics in 4 counties: Addison, Chittenden, Rutland, and Washington. The court clerks have graciously agreed to block schedule rent escrow hearings. So we attend court mostly in person at this point, sometimes virtually, and the clerks block schedule either for a morning or an afternoon. So we appear and then provide legal services to defendants in eviction for the morning or the afternoon in those locations. So the clinics allow us to jump into one hearing in the case using Vermont's limited appearance rules. So we're able to provide representation at the rent escrow hearing only and then withdraw from the case, which allows us to provide a higher volume of services. And it also makes it a lot easier for volunteers to participate because their time commitment really just consists of that morning or that hearing that they do. So it's a way to participate and volunteer, but in a way that maybe makes sense with the other things that are making demands of your time. So we know this program makes a huge difference for tenants. And I can tell you firsthand from speaking with clients, the amount of relief that usually I see in my clients when they know that they're going to have an attorney, they're going to have guidance and help that day. It really provides a huge service for the community. And it also helps make things move a little bit faster for the judiciary when both sides are represented. We're often able to come to quicker resolutions. We're able to enter orders that are stipulated. Both sides are participating, and it does make the court process a lot more efficient. So clinics really are, with the exception of Washington County that has had some issues with recent flooding in Montpelier, all clinics are in person with an option for WebEx. We do hope that things are up and running in Washington County soon, but I'm not sure when that will be. So we will skip to the next slide. Oh, I do see a question. Why no clinic in the Northeast Kingdom? Part of that is that, just to give a brief history of the clinic, we started it as a pilot in Chittenden County in 2014, and in 2016 got a grant to expand to 3 additional counties. So we do 4 total. Those 4 counties actually represent 50% of Vermont's population. And resource-wise, that is about all we can handle for now. We would love to see clinics statewide, but we frankly just don't have the attorneys, the volunteers, or the resources, although we certainly hope to have that one day. And I don't know that all the courts have the ability to block schedule. Anyway, it's sort of a longer term goal, but at this point we don't have clinics statewide. So as some of you may know, we, for a period of about 2 years, maybe a little bit longer, had the benefit of VRAP, which is Vermont's Emergency Rental Assistance Program. That program helped provide up to 18 months of back rent for tenants. It was hugely helpful. It helped us. It was a great tool in the tool belt, helped us stop a lot of evictions. But that program did run out, and all payments stopped as of June 30th of 2023. So that meant the last rent payment would have gone out for the month of June. I think some of them lagged and got paid in July, but all that is to say that program is not accepting new applications. It's not a benefit that's available to Vermonters anymore. So largely folks are, if they need rental assistance, they're going to their local OEOs, Office of Economic Opportunities, and other sources of rent payments, including HOP funds. So VRAP was great. We miss it. It is just not a tool that we have at this point. We've also seen as in the last, I would say, year, no cause evictions have increased from about 20% of all evictions to 50%. We're definitely seeing non-payment cases continue, but a lot of non-payment cases are also, landlords are also pleading no cause in addition. So people are filing multiple notices and evicting on multiple grounds. So there are just limited public funds to help tenants get caught up. As I mentioned, a lot of that's county specific, community action agencies. And the real challenge that we're seeing lately is because there are so many no cause evictions, we're limited in the things that we can do. What we can do is try to negotiate move out deals, but there are very rarely strong defenses that we can raise in a no cause case that will result in someone being able to retain their housing. So even if folks get caught up in rent, they're still looking at this no cause, and they're still looking at the likelihood of having, unfortunately, to move. So very briefly, Vermont's housing statistics. I feel like if anyone has just briefly turned on the radio or glanced in a newspaper, you know that the housing situation in Vermont, as well as nationwide, is really difficult. It's an extremely tight market. We've seen a large increase in the number of homeless individuals in Vermont. As you can see, it's climbed, hugely from 2019 to last year. Vermonters have to earn pushing up to $24 an hour to afford a 2-bedroom apartment. As of 2021, that amount might be higher in Burlington, Chittenden County area. And the vacancy rate for rental homes is at about 1%. I think it's been at about 1% for quite some time in Vermont, and a healthy market usually has 4 to 5%. So as a result, what we're seeing with our clients that are in the position of having to move, they're just not able to find another apartment. It's not going to take 1 to 2 months to find another apartment. It could take 6 months to a year because there's just so little available. We also are noting that the maximum monthly SSI benefit has for seniors and disabled individuals, it's $893 just for one person, for $1,360 for couples. So this is, some Vermonters do live on this as their entire income, and it's just not enough to afford an apartment in the fair market. Bradley, I'll hand this one off to you to hear more about volunteering with the rent escrow clinics.
Sounds good. So when a person volunteers at rent escrow, first, what is rent escrow? So in any eviction proceeding where a tenant owes and is behind on rent, landlords can ask the court to order the tenant to start making rent payments into the court clerk while the eviction is pending. So if the eviction is for no cause, but the tenant is also behind on rent, even if the eviction is not filed as a non-payment case, the landlord may indeed ask for rent escrow. So it's just any eviction proceeding, as long as the tenant owes and is behind on rent, the landlord may ask the court for rent escrow order. If the order is granted and the tenant misses a payment, they can be evicted by writ of possession for failing to make that payment even before hearing on the merits. And so rent escrow is a critical time to help tenants preserve their housing or find a plan to take control of the process and do a sort of soft landing when after weighing their options. So when attorneys volunteer, if you're in person, check the masking policy before you arrive to the court. I don't think in the last year the courts have had much by way of changing masking policies. I think most courts don't. But in this day and age, I think it's always good to just double check anyway. We usually arrive at the courthouse about 15 minutes before the first case is docketed. Some of us will be there a hair earlier to review the cases. We'll have everything printed out and physical files for attorneys to review and things of the sort for the day. It's easy to spot us finding the clinic volunteers and the staff in one of the meeting rooms or outside the courtroom. And we will have prepared a court file for each defendant and attempted to do outreach in advance. So we will hopefully have a sense of some people being able to attend, but of course, not everyone is able to respond to our outreach, and we're not always able to outreach successfully to every defendant. And so volunteers during this time before the first case, volunteers have an opportunity to kind of review the files with us, go over the paperwork, do some quick issue spotting before the defendants appear for their hearings. Once the defendants start appearing, clinic staff will connect unrepresented defendants with volunteers. Interested tenants will fill out an intake sheet, and which includes contact information, demographic, and eligibility information. We are funded by grants, so we do have some restrictions on folks that we can serve, mostly income-based restrictions. But more often than not, that's never a problem for us. And, or excuse me, a problem for tenants receiving services from us. I think if folks are finding themselves in an eviction proceeding, more often than not, they are low income enough to be eligible for our services. So clinic staff will also assist you in preparing just kind of a limited scope retainer, a pro se appearance form for the tenant, a limited appearance form for the volunteer attorney, and a notice of withdrawal forms. So we have your ins and outs prepared for you while you're meeting with the client. After the hearing, the volunteer attorneys withdraw and have no continuing obligation. We may follow up with individuals if they need assistance with an answer and things of that sort. But for volunteers, there's no obligation to provide further services. Volunteers are welcome to do that if they'd like, but there is no obligation to do that. Just a note about WebEx, most hearings, I think all of our counties are hybrid, and which is a great opportunity in terms of access to justice for some of our clients who find it difficult to get to the courthouse. And volunteers may volunteer on WebEx as well. We do encourage volunteers to volunteer in person for the first couple of times, just to kind of get your sea legs, so to speak, because the process can be a little confusing on WebEx. So for kind of experienced staff and volunteers, it's a little bit easier to volunteer on WebEx. But the processes are similar. We ask volunteers to sign on about 15 minutes before a scheduled hearing. Clerks can arrange breakout rooms to discuss with defendants. And we have, we've been able to navigate this process for the last couple of years. I think we've got it pretty much down to a T. And courts typically allow volunteers to enter a limited appearance and withdraw on the record, and we haven't had an issue with that at this point. So a little bit about attorney ethics. So the ethical rules are somewhat relaxed under certain situations when you're volunteering with us. So we are a nonprofit legal service program. And so a lawyer, so a volunteer under the auspices of one of these programs, can provide short-term limited legal services to a client without the expectation by either the lawyer or client that the lawyer will provide continuing representation in the matter. However, we are volunteers are subject to the conflict of interest rules only if that volunteer lawyer knows that the representation of the client involves a conflict of interest. So the standard is a little bit higher. It's actual knowledge of a conflict. In this day and age, what practically happens is when volunteers volunteer with us, I send them the docket ahead of time, and some attorneys who have limited access to Odyssey for whatever reason. I think we have heightened access ourselves. I can send files and things of the sort to volunteers ahead of time. And then so when I do that, you have to do a conflict check anyway. So for the most part, unless you haven't received that information from me prior to you volunteering, I mean, for the most part, you will have to check the conflicts because you will know ahead of time. But if you don't know ahead of time, you only have a conflict if there's actual knowledge of a conflict. This slide just kind of goes over what I was discussing. We volunteers are covered under our malpractice insurance. I think if you have your own malpractice insurance, ours is secondary. And after the clinics, cases are open to LSV where the client gets referrals and follow-ups and things of that sort. And so in terms of conflicts and things of that sort, I think it's fairly straightforward. No actual conflicts, and when you get the information from us ahead of time, you just run a quick conflict check at your firm. There are other volunteer ethical duties, and all these duties are the same. Whether you're, regardless of how you discover the clients, we have the same ethical obligations for confidentiality, competence, and communication with our clients. The communication rule, you're in and out the same day. So it's kind of funny because our limited scope retainer is usually same day, and it says we'll keep in communication with each other, as is our ethical obligation, but you're in and out the same day. So there is no expectation of ongoing communication, but while you're out at the court representing folks, you have that same obligation to be able to communicate clearly with your client in a way that they understand, as well as rules about competence and confidentiality. And I believe that is it for this section. So Maggie, I'll go ahead and hand over the substantive law piece to you.
Thank you. And just another plug for it, just as important as the limited scope retainer agreements are, equally as important is the client completing a notice of pro se appearance, which we're going to get into a little bit more later. But if the court does not have a way to contact the defendant, they are hesitant to let out the attorney whose contact information they do know. So clinic staff are really great about helping make sure all that paperwork is done. And we've certainly got an eye on that, making sure it happens. But when you file those sets of paperwork, it's great for your client to also have their pro se appearance in, so the court knows how to contact them, and it makes your withdrawal seamless and easy. So I will get into sort of a little bit broader landlord-tenant laws in Vermont. The next slide is really here primarily for your reference. I have huge confidence in everyone's ability to read and do research. So I know that you can find all of these things on your own, but so it's sort of at your fingertips at a clinic. Generally, most of the rules that we're working within live here. Primarily, we're working with the RRAA, the Residential Rental Agreements Act, and ejectment procedure. So we're looking at Titles 9 and 12. And to a limited degree, we're looking at the rest of these other rules. They don't come up as often. A lot of these are habitability related. So we're not touching on these as frequently. If a habitability related issue comes up, that's going to be an evidentiary issue, right? It's going to be an issue of proof for the court. So it's not always something we get into at rent escrow, but sometimes it is. Sometimes your client comes with a bunch of things that you can present that day. So if that does come up, then we look more at, the rental housing health code and things of that nature. And these other items less often, but we put them here for your reference because it is possible. I did have a lead paint case come up one time. So these things are possible in terms of what you can see. As far as tenants' rights, tenants have a few sort of basic rights in Vermont. And the main one is that they have the right to safe and clean housing. They have the right to a habitable apartment. They have the right of quiet enjoyment and exclusive use of their apartments, with the right to exclude all others. So I've seen cases where the landlord has decided, I actually would like to move back in. That's not allowed. If they're rented to the tenant has exclusive use. Tenants have the right to get 48 hours notice before a landlord accesses the property and landlord access to the property is limited to a certain number of things. If the landlord can access the property in an emergency, for example, if water's coming up from under the door or flames are coming out of the building, they can get in if they need to. But aside from an emergency, landlords do need to provide 48 hours notice to perform inspections, to make repairs, and to show the apartment to prospective buyers or future other renters. In Vermont, landlords are not allowed to charge application fees. That does not apply to credit checks or criminal background checks. Sometimes those are used as ways to skirt this, but charging a fee to apply for an apartment is something that's prohibited in Vermont, as is retaliation for, reporting unsafe or unhealthy condition in the apartment. Tenants are required to notice if the landlord wants to terminate the tenancy, and they're also required to notice if a landlord is going to increase the rent. So far in Vermont, there are not caps on rent increases, so a landlord can increase it by quite a bit if they want to, and it does not have to be commensurate with repairs. It doesn't have to match up with the fair market. They're allowed to increase the rent and set it at what they think the market can bear, but they do have to provide 60 days notice in writing to the tenant for that rent increase to be valid. Some additional tenants' rights. Landlords can't force a tenant out without a court order. This is a huge deal. I think a lot of tenants receive that initial notice to quit, and sometimes it can be worded in such a way that they think the notice means that they're required to leave just simply at the behest of that notice, which is not true. I often advise my clients that the only person who can tell you that you have to leave and you have to listen to that is a judge once they've said that and they've issued a court order. Landlords can't use self-help to evict tenants, which are things like the landlord is sort of trying to circumvent the court process by changing the locks, terminating utility service, removing personal property or throwing things away. If that happens, that's an emergency and that requires an immediate response from, the police are definitely a first phone call, but it also is something that a lawyer can help deal with to file an injunction or take other legal action to stop those things from happening. Tenants also have the right to be free from discrimination based on membership in a protected category. We've put the citation for what those categories are here. They have the right to be treated with good faith and fair dealing. There's also security deposit law in Vermont that covers what a deposit can be used for and the manner in which it needs to be returned. We'll touch upon this later, but when we are negotiating some sort of stipulation in the case, we usually address the security deposit as a part of that stipulation. Either the landlord can retain it and apply it to unpaid rent, or we determine the manner in which the deposit will be returned. Sometimes I even just say the parties will follow the security deposit law, which is that once a tenant leaves, a landlord has 14 days And in that window of time, they need to provide a letter to the tenant indicating, here's your deposit, I'm returning it, or I'm returning part of it, or retaining all of it. And here's the itemized list of reasons for why I'm keeping that. And sort of, I had to replace a door that cost $100. I had to deal with some holes in the wall that cost this. And they have to provide that itemized list, and failing to do that means the tenant can then access potentially another court process to try to get the deposit back. Another note is that lease agreements in Vermont do not have to be in writing. It generally is better when they are, and there is a lease that the parties can point to, but leases can be made verbally in Vermont, and they can be valid if they're formed that way. So I just went over tenants' rights. Tenants also have obligations, and those obligations include they are required to pay rent without demand or notice. So, for example, if your lease says the rent is due on the 1st of the month, that's your notice. That rent is due on the 1st of the month. You're not entitled to a monthly reminder. You are expected to make that payment to your landlord on the day that it's due in the manner that you've all agreed that it'll be paid. Tenants have the obligation to not disturb other tenants' peaceful enjoyment of the property, not to damage the property or create a code violation. I mentioned the access policy earlier. Tenants need to not unreasonably deny the landlord access to their apartment. So if a landlord's given that 48 hours notice, would like to come and inspect, they're planning on painting, or the tenants mentioned a repair that they want, if the landlord gives that 48 hours notice, it's not reasonable for the tenant to say that time doesn't work for me, or I'm not going to let you in. You do need to let the landlord in to address those repairs, especially if those are repairs that you've requested yourself. Tenants are obligated to comply with other terms of the rental agreement and vacate the unit upon lawful termination of the tenancy. So there are also some special situations in landlord-tenant law. So I guess I don't want to say the majority of the time, but perhaps the majority of the time, most of the landlord-tenant cases that we see are private landlords renting in the fair market to tenants who are renting from them. But sometimes some of those tenants will be in that rental agreement with a third party because they will have a subsidy. So there is a third party that is helping to pay for that tenant's rent, and that can be in the form of Section 8 housing vouchers. There are many different types of Section 8 housing vouchers. There are vouchers that travel with the tenant. Those are housing choice vouchers. So you apply a voucher, the tenant applies a voucher that they have to an apartment in the free market, or a voucher can be attached to a building or a unit that is subsidized itself. It does not go with the tenant. There are shelter plus care vouchers, vouchers for veterans, various and sundry types. If you see that that your client has a subsidy, certainly let us know right away, because there's some special situations and rules that come up in evictions with those that we can talk with you about. And there's also special rules relating to mobile home parks. I mentioned our rules mostly live in Title IX and Title 12, but mobile home park rules live in Title 10. And there are some big differences in what's required of mobile home parks when they evict a tenant. That's not required under Title IX. That's not required by landlords that are just renting apartments in the free market, that not in a mobile home park. Some of those significant differences, just very briefly, are mobile home parks have to have a written lease. You cannot do an oral lease in a mobile home park. The notice to quit has to be served by certified mail. There's other issues that come up. We do not expect anyone to be an expert in Title 10, but if you get a case where there's a mobile home park, let us know and we can talk with you about that too. So the basics of possession. So a tenant, as I mentioned earlier, a judge is really the only person with real authority who can tell a tenant that they have to leave, and the tenant has to follow what the judge has ordered. But the tenant retains possession of their home until one of three things happen. So you could have a landlord give notice that the time period that we've agreed to rent to you is up. that time has come, it's on this day that we both know is coming, and the tenant knows that's coming and is able and willing to surrender possession at the end of the rental period. That is acceptable. That is one way possession can be transferred back to the landlord. The landlord can also use the legal steps that exist to end a rental agreement, and that requires, providing notice, going through the court process, and then getting a court order for possession to be restored to them. And in some instances, the tenant may abandon the property. There's still a legal process that the landlord has to go through if they believe that that's happened in order to still get lawful possession. There's a certain amount of time they have to wait. Occasionally, we will see on the rent escrow docket a case for abandoned property. It's pretty uncommon for a tenant to attend that hearing if they've abandoned the unit, but if they have, it may be something we advise on. But as we discussed earlier, self-help is absolutely not allowed. These are the ways that landlords get possession back. Doing anything to shortcut or circumvent the law is illegal, and landlords are not allowed to do those things. All right, so this is a larger section, the eviction process. Bradley and I will split it up, but he's going to start us off with the steps in an eviction.
Right, thanks, Maggie. And so get started here on the eviction process. So here's a quick overview of the process. Landlords start the eviction process by issuing a notice terminating tenancy. The tenant doesn't vacate by the end of the notice period, or it doesn't cure the notice. The landlord will file a summons and complaint with the court, or file a complaint with the court and receive a summons to then serve on to the tenant. Tenants can issue motions to dismiss or motions opposing rent escrow prior to the rent escrow hearing. There are also motions to dismiss that can happen after the rent escrow hearing as well, as long as they were not the type of motion to or type of defect have been waived upon appearance. But for the most part, you will find yourself assisting clients right in the middle of the process. And the rent escrow hearing may be served with a summons and complaint, or a hearing on the tenant's, may be served with a summons and complaint and scheduled. The motion for rent escrow can also be served after the fact. So sometimes landlords will file a summons and complaint with the court without a rent escrow hearing. The tenant answers, and then the landlord will file a motion to pay rents into court after an answer and things of that sort. So this process isn't 100% the end all be all, and things can happen a little bit differently. So if a tenant does a motion to dismiss prior to the rent escrow hearing, the court should hear the tenant's motion to dismiss prior to hearing the landlord's motion to pay rents into court. The reason is that if there's a dispositive issue in the case, there's no reason to move forward with an escrow hearing. If there is a dispositive motion that's pending, should that be granted, then the case gets thrown out. And then after the fact, answer, status conferences, trial, and then the writ of possession can happen after the rent escrow hearing. So for the notices, all notices must be in writing. So texts and emails don't count under Vermont law. They could be mailed or hand delivered to the tenant. Certified mailing is not required. Actual notice means receipt of a notice. Written or hand delivered note, written notice must be hand delivered or mailed. If it's mailed, there is a rebuttable presumption that the notice was received 3 days after mailing. And the notice must be received the requisite number of days before the termination date stated in the notice. So it's a landlord's burden to prove receipt of the notice and prove that they gave actual notice, right? And so the actual notice is the writing that was either hand delivered or mailed. So how much notice is required? For non-payment of rent, it's 14 days generally, but it's 30 days if the property is subject to the CARES Act. It's a little odd to still be talking about the CARES Act. However, that law is still in effect for subsidized housing. or housing where the tenant receives a subsidy, and in housing that has received some kind of government funding or a government-backed loan or things of that sort. It's a little complicated, but it is the landlord's burden to establish whether or not they are subject to the CARES Act. And because if they are, the non-payment period extends to 30 days from 14. You can find this information yourself at housingdata.org/find-rental-housing. That's been a good resource for us to kind of double check things. And then the CARES Act form itself is on the judiciary's website. A violation of lease is 30 days. So if the tenant is accused of violating a lease term, that's not just non-payment of rent, they get a 30 days notice, or 14 days for dangerous or criminal activity. And then for no cause, it gets a little bit more complicated. So if there's no written lease, and the tenancy is 2 years or less, that's 60 days notice. 2 years or more, it's 90 days. There's a written lease, that's a little bit less. The notice period is shorter for non-payment, or excuse me, for no cause. 30 days if the tenant has lived there for 2 years or less. It's 60 days if it's more than 2 years. And if the property is sold, it's 30 days so long as there's no ongoing lease for a given term. One thing about no cause is that our reading of the law is that you cannot terminate a tenancy for no cause if it's during a lease term. But a landlord can terminate for no cause at the end of a lease term, or if the lease term is month to month. There's some Burlington specific protections. Basically, if there's no written lease, you get an extra 30 days. It's 90 days for less than 2 years, and it's 120 days for 2 years or more. Eagle-eyed folks have noticed that it's 90 days that the tenancy has lasted for less than 2 years, and 120 days for 2 years or more. The state law is it's 60 days for no written lease. It's 60 days if it has lasted for 2 years or less, and 90 days if it's lasted for more than 2 years. So there's kind of like a slight discrepancy there with that 1 day. Rent increases must be 90 days in writing, and there's some additional security deposit protections as well for tenants. The rent increase piece is good to know when you're advocating for rent escrow, because landlords do have to establish what the rent is, and so often a lease will say the rent is $800, but the landlord's asserting that the rent's actually $1,000. And if the tenant disagrees with that they owe $1,000, the landlord will have to establish that they properly raised the rent. So it's good to know those kind of protections. Some common errors in terminating a tenancy. So a specific termination date does have to be stated in the notice, and it must be the correct numbers of days. So it can't just be 30 days from now, you have to move. It has to say, on August 31st, you have to move. So it does need a specific date, and then that specific date does need to be the actual number of days for notice. Non-payment, Vermont courts have interpreted Vermont law to require a redemption clause in non-payment cases. So Vermont courts require that landlords must notify the tenant the exact amount of rent and only the rent that they owe to cure the non-payment before the 14 or 30-day notice period expires. There's some landlords council who kind of disagree with that assessment, but Vermont courts almost uniformly require that the landlord has to notify the tenant that they have the right to cure a non-payment and then how much they owe. And those are just kind of for straightforward consumer reasons. You need to know how much you have to pay in order to actually exercise your rights. So that's why the courts require those things. If the unit is subsidized, notices terminating tenancy must be sent to the housing authority at the same time as the tenant in order to be in order to be active. So it's called contemporaneous notice. And if there is a specific lease violation, that notice must be, or excuse me, that notice must specifically say what you did wrong. It couldn't just say you violated the lease. It says you violated the lease because you were smoking inside the apartment or something of that sort, right? So it has to have some kind of specificity for specific lease violation notices. And notices terminating tenancy in subsidized cases must also notify a tenant of their rights under the Violence Against Women Act, VAWA. That's not in the slide, but that's an important thing to keep in mind. And another thing we just kind of want to highlight here is that the landlord can't force a tenant to leave on a termination date. They must proceed with a court process. And then the caveat here that some judges interpret statutory requirements differently. The rubric on this page is that the vast majority of judges will rule in accordance with these rules. But some judges do interpret statutory requirements differently. And so that's always a caveat to keep in mind. Maggie, I think I'm handing this off to you here.
Thanks. Yeah, and before I get into this, just some follow-up pieces of what Bradley just went over. I just want to acknowledge we say a lot of numbers, like there's 14 days, 30, 60, 90. What does it all mean? And I don't feel bad about needing to refer back to this presentation or the statute. I need to look at the statute routinely, and this is mostly what I do. So there's a lot of different notice periods, and it's fine to just quickly refer back or ask one of us because it's hard to keep track of. There are a lot of different periods of time that apply in different circumstances. And something else, Bradley, you mentioned about rent increases reminded me that recently I had a case where the landlord alleged there was a rent increase, but they had no documentation of that rent increase, and they consented to a rent escrow order under the old rent amount. So it is valid to sort of push back on if your client has not gotten written notice of the rent increase or the written notice was insufficient. It's a good thing to push back on because sometimes the other side will agree that it wasn't valid and we'll stick with the old amount for now. So moving on, so Bradley talked a lot about terminating the lease. Once that's been done successfully, a landlord may file eviction paperwork and serve it to the tenant, which then takes the process into the court. Initial service has to be done by a sheriff. So a lot of the times when I'm trying to figure out where my client is in the process, I ask if a sheriff has come to give them paperwork. And all other papers can be served personally by mail or some things by agreement of the parties. So those types of service are governed by Rule 4 and Rule 5 respectively. But again, service has to be initiated in person by a sheriff. The only way around that is to get a TAC order. Tenants have 21 days to file and serve their responsive pleading, which is either a motion to dismiss or an answer. The 21 days you start counting on the date that the paperwork was received. And if tenants are served a motion to pay rent into court, they don't have to file their motion to dismiss or answer until 14 days after their rent escrow hearing if they haven't previously defaulted. So what that means is that if you get the notice of hearing, you attend the rent escrow hearing, that attendance gives you an additional 14 days to file your response. If you don't attend the rent escrow hearing, the landlord can move for default. We've run into some confusing territory when the rent escrow hearing is served longer than 21 days after service. So what happens if you're served and rent escrow is not until 40 days later or longer? I mean, we've seen some big gaps in that due to court scheduling. But the notice of hearing from the court does say if you attend the rent escrow hearing, you get an additional 14 days to answer. So we've seen landlords attempt to file a default, prior to the rent escrow hearing, but the judges that we've been appearing in front of have been denying those because they've represented on their notice of hearing, and the statute indicates that if you attend your rent escrow hearing, you get additional time. If they haven't had that opportunity yet, a default is premature, and generally those are denied. So what does the summons have to include? There is a form, so I think most people tend to just use the form, which has a lot of this information, but it has to indicate the name and address of the court where you're being sued, the name and address of the attorney or the landlord if they're unrepresented, where service can be mailed, how much time they have to respond, which is 21 days. It is still important to look, because even though we've had a day is a day for what, 5-6 years at this point, and the form is available online, every once in a while I've seen a landlord or an attorney pull the wrong form in error, and it gives 20 days to respond, which were the old rules. And that's not good enough. That's not giving enough notice to the defendant. It's a due process issue. It's a potential basis where you can get a case dismissed if the summons is defective. The summons also has to come with it a blank notice of appearance form, blank answer form, which is a relatively new rule. And the summons has to include a warning that if you fail to answer or otherwise respond to the lawsuit, it could lead to default, which means you can lose the case simply by not participating and not responding in writing. With the summons, the landlord or their attorney will file a complaint, which is a numbered list stating the grounds of eviction and the relief sought. I usually refer, when I talk to my clients, that this is a list of allegations against you and you have to respond to those allegations. The grounds have to reflect what's noticed. So the complaint cannot include, like if you just got a no cause notice, the complaint can't also say, and this tenant has cause damage to my property. Here's what those things are. If they were not noticed prior of those for cause reasons. No attorney's fees can be awarded unless they're provided in the lease or the eviction's being brought due to serious material breach of the lease. So in other words, I've seen landlords move for, I think Bradley, you too have also seen lawyers request attorney's fees when the lease is silent on those. And I think you and I have both been successful on getting those requests for attorney's fees stricken when the lease doesn't provide for that. The plaintiff also has to include in their initial filing a copy of the written lease if there is one, a copy of the notice to quit, and starting in the pandemic, they had to file a declaration of compliance with the CARES Act, which frankly, I thought was going to be a short-term thing, but now that is a part of the Vermont Rules of Civil Procedure in Rule 9.2. So the CARES Act certificate does have to be there, which essentially indicates that a property is covered by the CARES Act. They also have to indicate if the property is not covered by the CARES Act. If a property is covered, then the notice to quit for non-payment, which is normally 14 days, has to be 30 days if the property is covered. So the rent into court hearing and process, I mentioned earlier that those rules live in Title 12. So for the rent escrow hearing, a landlord at any time can request that the court order through a hearing that the tenant make rent payments to the court clerk directly while an eviction is pending. This can happen in any type of case. I just yesterday saw a case for no cause where the landlord was asking for a rent escrow order. You can do that if you can show the court that there has been non-payment. So by doing that, a landlord is filing a motion for a rent escrow hearing that the court then schedules. So when a landlord is asking for a rent escrow order, they can't get an order for the entire arrearage that's due. They can only get the rent amounts from the date of the filing or the date of service, whichever came first. So rent escrow hearings, a lot of time my clients will show up at the hearing and there's a long history between them and the landlord. There's likely a decent story there, but not a lot of that. And that's all going to be relevant at the trial, right? But at the rent escrow hearing, really, it's primarily about money. Who owes who what and how much. So judges tend to push back if parties try to bring up other substantive legal issues like, they will entertain access issues, I think, but they don't really want to hear about everyone's grievances with each other. Again, that's an issue that is relevant at trial, but rent escrow is just about establishing, does the tenant owe rent money? And if the answer is yes, is the judge obligated to enter an order for payment of rent into court? So some courts will consider habitability defenses at rent escrow, but as I mentioned earlier, that's an evidentiary issue. Unless the landlord's going to come forward and agree with all of those things, a tenant will have to prove that there are problems with my apartment that I can provide evidence of today that render it either not worth, the full rent or any rent that my landlord is charging. Another note is that a tenant has to actually physically live in the apartment in order for a rent escrow order to be issued. If a tenant's moved out, even if rent is owed, a judge cannot issue a rent escrow order. And the way that our office looks at rent escrow is that, anytime the parties are in court together, it's a time for each side to communicate through counsel. If you've got it, our clinic makes that possible. But everyone's together. It's a good time to assess where is the other side, what are their goals, and can we reach an agreement? So sometimes rent escrow is an opportunity to come to a global resolution of the case. Sometimes we just stipulate to a rent escrow order. And if a tenant is ordered to pay rent into court and does not make that payment, they miss the payment, the landlord can get a 5-day or 5 business day writ of possession for failing to make that payment. So when we talk about our clinic program and rent escrow and the importance of volunteers, rent escrow really presents itself as an extremely vital time in the eviction process, and it represents a really critical decision that's about to be made. If you miss that payment, you lose possession of your apartment, and that's even before there's a hearing on the merits. That's before you get to tell your side of the story. It's losing possession just for failing to make this payment, which is why legal advice and some assistance from an attorney at this point can be so critical.
And Maggie, I just wanted to mention that it's actually a 7 calendar day writ of possession now. So the slide's outdated slightly. I think the rule changed a couple of months ago. So I'll be sure to update that before I send this out to volunteers.
Thank you. I still think of it as business day, but yeah, you're right. Thank you.
It'll only make a difference around holidays and things of that sort. Like if you're, the day before Thanksgiving and things of that sort. So mostly observational equivalents, but it's best to just make sure we're staying up to date with the rules here. So sorry about that, folks.
That's okay. That's why we update the presentation as often as we can, because these things do change, and they can change pretty quickly. So after a tenant answers and files a written response with the court will usually, depending on, and sometimes depending on what the parties request at rent escrow, they'll either schedule a status conference to determine whether or not the parties are able to come to a resolution. Sometimes I will ask for a status conference because my client needs time to come up with rent money. They need to sort out their benefit. The parties want time to work with each other. And sometimes, one party is just ready to go to a merits hearing and sort of wants to get there as quickly as possible. But rent escrow is also a time where you can weigh in on what happens next, and the judge is usually looking to you, to the attorneys, to figure out what's my next step. What do I put on the calendar next, and how do we keep this case moving forward? So if a landlord is going to get a court order for possession, the ways that they get that is if a tenant defaults. That's if they don't respond at all. They don't attend rent escrow. They don't file a written response. They've been properly served and they don't participate in the lawsuit. A landlord can get a writ of possession via a default. They can also get a writ of possession, as I discussed earlier, if a tenant is subject to a rent escrow order and misses those payments. The letter of the law really is that even if you make a rent escrow payment late, a judge is still obligated to issue a writ of possession for not following that order. But depending on the circumstances around that, there may be other steps that we can take to try to retain possession if there's potentially very good cause or excusable neglect for missing that payment. The landlord also gets a writ of possession if the case goes to trial and they win, and the judge orders that they have possession, or if the parties come to some sort of agreement. This happens a lot at rent escrow, but sometimes I've had clients who are not ready to commit to a move-out date, who are not ready to agree at the rent escrow hearing, but maybe a week or two later, circumstances have changed and they are ready to stipulate. So that can happen at any time, but sometimes the move-out deal or stip that you arrive at includes the parties consenting to a writ of possession and agreeing together on what day that writ is going to be executable. So if a tenant does not appear at rent escrow, a writ that's issued for failing to make a rent escrow payment if they've missed that hearing is you would get a 14-day writ. So you would be required to move out 14 days after service. If you attended the rent escrow hearing, again, that's 7 calendar days. And a writ of possession, in the majority of circumstances, is going to need to be served in person by a sheriff, but you can waive that service by stipulation or agreement. And it's possible to do that if you were in court with your tenant and that person can accept service right there with you that day. Okay, so we'll sort of getting into the nitty-gritty of rent into court basics. I'll hand it back to you, Bradley.
Actually, Maggie, I'm going to ask that you go over this slide because I need to step away, but I'm just going to mark down the time really quick, and I will be back in just 2 minutes.
No problem. Okay, so I will start with rent into court basics and just sort of give an overview of rent into court. So again, I think I mentioned this earlier, but at the rent escrow hearing, landlords are not able to make a request for the entire arrearage, although sometimes they'll try. But what the court only has the authority to order is the amount of rent that has accrued from the date of filing or the date of service, whichever happened earlier. So when you are negotiating sort of a rent into court order or at a rent into court hearing, I'm kind of looking at a couple of things. Is there a way that we can completely settle the case? It would be great if we could, right? So sometimes that would mean stipulating to a move-out date, stipulating to a repayment plan. If your client's just ready to move and the landlord's willing to accept that move date in exchange for a waiver of back rent, those are ways that the case can settle. It's certainly something that if you're looking at a settlement, you can come and talk to one of us about how to do that. The technology at the courts has gotten a lot better, so I have frequently typed up those agreements, sent them to the court clerk, printed them, and then we file them, and that's been that makes the whole process a lot easier. If it's not possible to come to a resolution of the entire case, which happens a lot, there's not a lot of apartments to rent, there's not a lot of opportunities to move, people aren't necessarily ready to commit to a full resolution. And if that's not possible, then we look at trying to stipulate to a rent escrow order and having the parties agree to a rent into court order that makes sense. I noticed we have some references to VRAP in there. Sorry about that. We don't have VRAP anymore. But some of the stipulations that for a rent escrow that I have done have included, sometimes my client doesn't have all of the rent that's accrued from the date of filing. And I just ask for a rent escrow order to start next month with the rent for next month and rent payments due prospectively. And depending on the circumstances, sometimes landlords will agree to that. And we can work, or we work out a payment of rent into court where payments are due, the 1st and the 15th to match up with payment schedules or when wages come in. This is a time where you can kind of get creative and do what you can through negotiations to get your client into a rent escrow order that they're confident they can pay and that they're confident that they can actually make those payments. Again, if they miss the payment, the consequence is huge. The case does not completely go away. It doesn't, that certainly other issues remain at trial. But if you are lose possession for failing to make a rent into court payment, that's a huge deal. So that's why you want to do everything possible to get your client into a rent escrow order that they're confident that they can pay. So let me see, Bradley, I think I'm ready to hand this off to you. I think everything else we've covered on this slide. If you're ready to jump into the next one, you can pick it up.
Sounds great. Thank you so much.
Yeah.
All right. So the landlord's motion to pay rents into court itself has to include a few things. The motion must include an affidavit in support of the motion that's signed by the plaintiff. The motion can be filed at any time, not just at the start of the ejectment action. It's most common to serve a motion to pay rent into court with the summons and complaint at initial service, but there are some landlords' attorneys who prefer to do that after the answer. And it is just kind of a matter of those attorneys' practice and kind of what fits best for them and their clients. And the tenant must get 14 days notice of a rent escrow hearing, and without it, the hearing should be rescheduled. So if the tenant gets like 13 days notice and they show up, they can say, I was entitled to 14 days and ask for the hearing to be rescheduled. The thrust of that is that the law allows a tenant 14 days to get their affairs into order so that they can be prepared to pay rent into court. And that's part of the statutory balancing of the landlord's interests and the tenant's interests as well. And of course, as we mentioned before, the motion to pay rent into court can be filed with any eviction only if the tenant owes rent and is behind on the rent. So meeting with your client, you definitely want to go over your client's goals. So does the client want to stay, or are they looking to move? Are there habitability issues that they'd like to raise today that have to be fairly well documented at this stage, but there might be some concerns there. Does the client actually owe the rent? Sometimes tenants say, I just paid $1,200 yesterday, and so they don't owe rent anymore. And can the client afford the apartment moving forward? And if the client knows that they can't afford the apartment moving forward, they might have some different goals in mind and can use our services to negotiate stipulated move-outs and things of that sort. And of course, does the client have alternative housing options? I think a lot of service to our clients is trying to help them stay in their homes, but also help assess a situation realistically. If someone's rent is beyond a client's income, for example, it's unlikely that housing situation is sustainable moving forward. And we might need to advise our clients that the best thing to do would be to negotiate a move out or, try and find a way to do a soft landing in terms of being able to leave on by agreement as opposed to by force. And then a little bit of a two-defendant problem when co-defendants are adverse. Obviously we can't represent both, so we represent the person who comes to us first. If co-tenants are not adverse, we obviously have to advise on conflict of interest and things of that sort. And if we decide to represent co-tenants at rent escrow and then they become adverse, we have to withdraw entirely. So we have to have that kind of conversation with tenants when there's more than one tenant more often than not, this is actually not an issue. But this is something to come up to make sure to remember your ethical obligations when advising to defendants. Common rent escrow situations, excuse me. Common rent escrow situations, the tenant cannot pay and the apartment's not affordable. Tenant can pay rent, but catching up will be hard. The tenant has a rental subsidy, or the tenant has moved out and the remaining issue is damages. In each of these situations, there might be a little bit of a different tack or a little bit of a different negotiation that can happen. We have seen payment plans be successful in preserving tenancies where a tenant, lost work due to an injury and now is back at work, but so they can pay moving forward, but catching up will be hard. And we kind of negotiate situations where we can preserve a subsidy and say, okay, we can't fix the situation retroactively, but we can negotiate kind of, a soft landing where, the tenant's interests are maintained by an agreement to move out as opposed to a court order for a tenant to move out involuntarily. And more often than not, when a tenant has moved out, so long as damages are not substantial, the landlord's going to likely dismiss the case. I say that, and that means the next time this comes up for me, that will not happen. But more often than not, I think a situation is the landlord's goal is possession, and and so long as the landlord hasn't or the tenant isn't super far behind on rents and the process has moved along with normal speed, the damages are going to be not something to scoff at by any stretch of the imagination, but would be something that the landlord is just more or less interested in walking away from. Negotiating with the opposing party. Obviously, we talk to the opposing counsel if there is one, or the landlord if there is not. It's always great when the parties are represented because we don't have to necessarily worry about that kind of trust issue that comes when you're a lawyer working with pro se litigants. We assess the landlord's goal and negotiate on behalf of our clients. More often than not, again, the landlord's goal is possession. But if the tenant can get caught up on rent, it does save, in the long run, I believe it does save a landlord money to keep a tenant who has a realistic expectation of paying moving forward, as opposed to proceeding with the eviction process, getting rid of this tenant, and then finding a new tenant to kind of come in and replace that tenant. I think just pure economics, it behooves the landlord to keep someone so long as that person can be, is not going to be a hardship for that landlord moving forward. And so that's part of that negotiation. But then again, sometimes some landlords just want possession, and that's, unfortunately at that point that is their right unless a tenant cures. We're looking at when we're negotiating, we're talking about stipulation. We're talking about it's not VRAP applications anymore, but sometimes there are community action grants and things of that sort where the landlord can be expected to get paid from a government agency or something of that sort. But the reality is sometimes we can't come to an agreement and contested hearings are necessary. And so we'll assist a tenant in raising defenses to rent escrow. This isn't the actual amount of rent. The rent was improperly increased. There are some habitability concerns that should reduce the amount of rent owed and things of that sort when we're negotiating. All right, Maggie, and I will hand this off to you.
Sure. And being mindful of the time, I'll see what I can, if there's anything we've covered already, and try to move through these slides. So I think we've talked a little bit about this, that when you're looking through a court file, if things are missing, you may have the basis for a motion to dismiss. So it's important that a court file include all of the things that are listed here. I just want to highlight that that a motion for rent escrow does have to come with an affidavit. You can't just make the motion and have that stand on its own. There has to be a supporting affidavit outlining that and swearing to the court that the tenant actually owes rent money, and there needs to be a lease if there is one, and a notice to quit. If it's missing those things, again, you can make an argument that the judge should dismiss the case. So looking at the notice to quit, so the importance of the notice to quit is the notice serves as the method of terminating the tenancy. If the tenancy is not terminated before a court filing, it deprives the court of subject matter jurisdiction, and judges want to know that. If they don't have the authority to do something on a case, they want to know that, and they will ought to dismiss it. So looking at the notice to determine if it was properly terminated, all of those windows of time that we talked about earlier that are so important, it's important to look at the date of the letter, the date of the termination, and see if enough time was actually given. If it was served by mail and not in hand, that notice needed to include 3 days for mailing, and the actual date needs to be specified. So that means a landlord can't say this note's dated June 1, and you have to be out 14 days from now. Vermont law says the tenant should not be in the position of counting those days. The date that they need to leave has to be provided in the notice. The tenant needs to be told if it's non-payment, how much money they need to pay to redeem, and that redemption amount can only be rent. The landlord is not allowed to include outstanding utilities, late fees, a lockout fee, things of that nature are certainly charges that they can ask for as a part of their case. But if they're at the notice stage, just rent is required to redeem. I think Bradley talked about the redemption clause, which generally judges are looking for in those notices to quit. For cause, lease violations have to be specifically described. I know there's a legal aid law where I think one of my colleagues had a client that received a for cause notice because they were acting goofy. And like, maybe that's actually charming. So that's not enough, right? That was too vague. And as I talked about the sort of the jumble of numbers and time, there isn't an accompanying chart that we have that's sort of a quick reference to determine if enough notice was provided. So I will just very briefly also touch on the FDCPA notice. So if a notice to quit is coming from an attorney, they have to disclose that they are debt collectors under the FDCPA. If they don't do that, then that is a separate claim against the attorney for statutory damages, not a defense to the eviction, but and a lot of my landlord counsel colleagues do, just as a matter of their practice, just stick this language in their notices to quit, just to protect themselves and comply with the law. But sometimes I've seen attorneys not do that, and if the notice to quit came from that lawyer, sometimes a respectful and private conversation that they've forgotten to do this, and indicating them of what the penalties they're looking at can result in that attorney voluntarily dismissing their case, and that could get your client some additional time. There's also 12B1 arguments that we can raise. So standing problems. So if a plaintiff's not a legal owner, doesn't have the authority to bring the case. If the plaintiff's an unregistered corporation or company, so we always have at least one laptop at the court, we can look up if they're registered in the state of Vermont to do business. If the plaintiff is trying to evict the tenant from the wrong address, or they're a corporation and they are not represented by an attorney, those are all 12B1 arguments to try to get the case dismissed. For notice problems, you can get your case dismissed for not providing a notice to quit. For lack of subject matter jurisdiction, the notice to quit did not successfully terminate the tenancy because it didn't provide adequate time, didn't give the right to redeem. That redemption amount includes money that's not rent. And as Bradley mentioned earlier, for subsidized housing, if the notice didn't comply with federal regulations, and the big ones there are that the notice has to be sent to the housing authority at the same time, and the notice to quit, even if it comes from a private landlord and their tenant is subsidized, has to include a VAWA notice. So some more 12b6 arguments. For no cause, during the initial term of a written lease, no cause is not legally permissible unless otherwise stated. But you can talk to us a little bit more if that comes up for you. For non-payment of rent, if rent is not owed, for example, the case was filed and since then your tenant has paid and they've got proof of that payment, that's a way to get the case dismissed. And for cause, for example, if the cause alleged is actually permissible under the terms of the lease, or perhaps the for cause allegation, the conduct actually was the result of a disability or other discrimination from the landlord. Other motions to dismiss arguments, which I have not, are possible, can happen, but I don't come up as often. The landlord filing in a county other than the county of the rental unit. Bradley, I think you had that happen once. Somebody did, but anyway, it's rare, but it has occurred. 12b4 grounds, the landlord failed to attach a copy of the written lease or the HAP contract. So, they're essentially trying to get out of an agreement and not providing that agreement for the court to see. We've already mentioned the subsidized housing and defective summons, no blank answer form served on a defendant. I have not seen a judge dismissed on that basis alone, but it can be an argument you raise, certainly if you have others. And failing to file a CARES Act with their case. Lastly, this has happened before, but certainly less often. 12b5 motion to dismiss would be if the tenant wasn't served with a summons and complaint. So filing defects are super powerful negotiation tools. It's definitely, a notice issue is a way to get your case dismissed, but sometimes you will learn in talking to your client that a dismissal is not really something that's in line with their goals. If they simply want additional time, if there's, they have an apartment that's going to be ready in 2 months and that's all the window that they need. It's something that you can raise by just talking with opposing counsel and saying, look, I found this defect in your filing. I can ask the judge to dismiss the case, but how about instead of that, we talk about this agreement that I think my client would be interested in. What do you say? So it's a tool that you can use, but sometimes, the best thing for your client is to make the argument for dismissal. And we've been successful in doing oral motions to dismiss, getting those granted. And we also offer to do briefing if a judge is not prepared to make a decision that same day. Okay, I think this is our last section, right, Bradley? So we'll be going over, we talked a little bit about settlements, more about what that looks like, stipulations, or contested rent escrow hearings.
All right, and we'll take it from here. So some habitability complaints, as part of the negotiation tool, I think we've gone over this. But the tenant should have given the landlord advance notice and have some kind of documentation of the habitability concern. But I think more often than not, insufficient evidence and/or not a serious complaint is not going to really lead to a reduction of the rent escrow order. The tenant can proceed with a complaint. In negotiation or a contested rent escrow. But I think if a tenant does come with something to present to a judge or an idea of what they would like from a rent escrow order that was not successful in negotiation, the tenant should have an idea. So it's, there's no fridge. So I think my rent should be reduced, $200 a month or something of the sort. For settlements, I think we can run over a lot of this kind of negotiating back and forth, but I think kind of trying to get down to the nitty gritty is really helpful. So why does the landlord really want, in a no cause situation, why does the landlord really want the tenant out? Is there something going on that we could address? If there's a cause type situation, would a reasonable accommodation cure the violation? And if the tenant cures the violation, will the landlord be satisfied, or is there something else going on? And then, of course, talking settlements with non-payment, we've gone over that because that's our primary area here. Drafting settlements in court or a clinic setting can be rushed and quick. So here's some tips to include. Include a move-out date. How will the writ be served? The condition of the unit afterwards. How, when the keys will be returned, what's going on with the security deposit, and if there's going to be payments made into the court or between the parties, how is that going to happen? Specify the amounts and the amount and manner of the payment. So here's a sample stipulation for us. You know, these are pretty straightforward. If a tenant is agreeing to judgment for possession, you know, the landlord's giving this much time, the tenant can stay until this date, and it's fairly straightforward and doesn't have to be super complicated, especially if we're agreeing to kind of waive rent or rent escrow and things of that sort. These agreements can be pretty straightforward. And then stipulating to rent escrow in terms of trying to come up to an agreement. We'll have template orders ready for you folks to use. You know, negotiating the amount due, when the payment is made. You know, I think at this point, us and opposing counsels are using approximately the same form, even though it's not an official form. I think over the years, we've all just kind of melded it together. So we kind of know how these things go. We're stipulating to rent escrow and moving forward from there. And then last piece, with the contested rent escrow, we can, of course, oppose rent escrow orally in the clinic setting. And there's some arguments that you can make when you're opposing rent escrow and contesting it in court. And then last, the tenants have 14 days to answer after their hearing. We have templates that we can provide to clients who appear in person. We also follow up with them afterwards. But I usually like to see my clients walk away with a good template. Even though these days they have the answer template from the courts, it's often really small amount of space that the tenant can use to respond to a complaint. So we usually like to give them a template as well. So thank you. Here's our contact information. Feel free to reach out to either of us with questions or if you'd like to volunteer. So I'm going to go ahead and stop sharing my screen to see if there's any questions. All right, and it looks like there are no questions. So with that, thank you, everyone. I really appreciate your time in joining us today. We will post this on our YouTube page. If you'd like the materials, just send me an email and I will provide the materials to you along with our notice to quit handout that has dates and things that make it a ton easier to navigate these tricky questions. Thanks again, everyone.
Thank you.